Good afternoon, everyone. This is the 145 panel Board of Zoning and Appeals. If you are in the wrong panel, if you're in the wrong place, now is your time to resituate. My name is Gerard. I am counsel for the past 8+ years to the North Hempstead Board of Zoning Appeals. I'm very pleased that we have a distinguished panel with us today to discuss BZA issues. From my left, your right, and I'm only open, I know all these people very well. I want to make sure I don't mess up the law firm names because that will really displease people. From my left, your right, Mr. Paul Bloom, partner in Harris, Bloom & Archer, distinguished land use practitioner. Rich Finkel, town attorney of the town of North Hempstead. The Honorable David Mammina, chair of the Board of Zoning Appeals for the past...
Going on 21 years.
Going on 21 years. Well, there you go. To my right, your left, Michael Levine, the Commissioner of Planning of the town of North Hempstead. To his right, Bruce Migatz, partner in Albanese, distinguished land use and zoning practitioner. And to his right, this is the one I was concerned about messing up, Michael Sahn, no, it changed, right? Sahn Ward
Baker.
Coschignano Baker? Oh, it is right. Okay. Sahn Ward Coschignano Baker, founding partner of that firm, and the third of our 3 distinguished land use and zoning practitioners on the panel today. So I'd like to thank all of them for taking the time to be with us today. As counsel to the BZA, I would be remiss if I did not recognize, one of them is here, one of them may not be here, the 2 individuals from the town attorney's office who give us tremendous support at the BZA on a regular basis. The Chief Deputy Town Attorney, Linda Zuick-Geffner, I know she's here. Linda, thank you. And Deputy Town Attorney Simone Freeman. We thank Linda and Simone for all they do. We are not the building department. We are the BZA. The BZA exists because of individuals who bring projects to the building department, large and small, residential and commercial, where one or more aspects of those projects are at variance with the code. And if the applicant receiving his or her disapproval notice setting forth the variances from the code that are necessary in order for that project to proceed, if that individual decides to proceed from that point of disapproval, the application is made to the BZA. And this board, which is a 5-member board, this board hears and determines those appeals based on standards set forth in New York State town law. If you're a BZA in a village, the standards are set forth in New York State village law and are very similar. I'd like to recognize our BZA members. I've seen, besides Chairman Mammina, our Vice Chair, the Honorable Don McCarthy, is right there. Thank you, Don. Our newest member, Honorable David Levine, is here somewhere. I've seen him. Right there. Right there. I have his glasses on. Okay, also Honorable Leslie Francis and Honorable Paul Allo. I haven't seen either one of them, and that completes the roster of the BZA. I'd like to start off this discussion by talking a little bit about the way the BZA has attempted to respond in conjunction with the Planning Department. The Board of Zoning Appeals is a little department which is part of the vertical of Commissioner Levine's department, the Department of Planning. A few areas in which we have tried to be responsive to the broader North Hempstead community with respect to our work in the context of the discussions you've heard so far today, particularly the discussion at lunch. One thing that we've already done, we recommended recently, and the town board adopted a process under which applicants who come to us, to the BZA, and obtain a variance for their project, they don't find that variance lapsing and expiring because they're unable to finalize their permits, or unable, let's say, to get a curb cut permit from the state DOT, or whatever the holdup happens to be. And that's a step forward that we've taken just this year, and that is a direct result of the broader conversation that you're all a part of today. It is really disheartening for an applicant to go through the process of obtaining a variance for his or her project and then to see it sunset as a matter of law because the physics of the project, the actual permitting and building, didn't get off the ground soon enough. So that's one aspect in which Commissioner Levine's been particularly helpful. The second thing I'd like to mention, Chairman Mammina, of course, he indicated that he's been chair for 21 years. And one of the things he's taken the leadership on over the past 6 months or so is scheduling, when they're necessary, additional, not BZA public hearings. BZA typically has two public hearing sessions a month. The Chairman Mammina has been putting together more administrative and decision meetings, off schedule, if you will, to try to move the calendar ahead, the BZA calendar, in a more efficient way so we get cases decided and we identify our more challenging cases as soon as possible and put in the time, roll up the sleeves, do the work necessary to make good decisions on those cases. And finally, with Supervisor Kamen, under his leadership, working with Commissioner Levine, plans and discussions are underway internally to reorganize and enhance some aspects of the staff support of the BZA, again, for efficiency, to get our work done in a more efficient way. So I just wanted to start off with those positives because those are things we're building on. And at this point, I'd like to ask each of the panel members here, besides myself, to introduce themselves to you, give you a word or two about their background, and if they have one or two issues that they are thinking of focusing their conversations on today, to indicate that. And so I'll go in the same order as I introduced them. Mr. Paul Bloom.
I am one of the founding members of the law firm of Harris, Bloom & Archer, LLP. We are land use attorneys and real estate attorneys. We run a boutique law firm that deals only with real estate related matters, both in litigation and transactional as well as land use matters. I probably have well over 35 years of experience. I have a number of partners and associates, and together we probably have well over 100 years of experience in the field. We've represented numerous clients through the years, and we've heard different numbers that were thrown around before: 13 towns, 2 cities, 93 villages, and there are 9 villages alone in the Great Neck Peninsula. But between myself and my colleagues on the board this afternoon, who are also in private practice, land use, as well as those who are from the town who had a private life before they joined the town, we probably have represented people, clients, in the greater percentage of all of those municipalities. And as a result, we see the differences that occur on a daily basis by going to a zoning board in a particular village or going to a town and finding things are quite different, notwithstanding they're all guided by basically the same law, either the town law or the village law, and as it relates to area variances or use variances, basically the language of the two codes under the town law and the village law are identical. And so we've heard today a number of comments, issues that have arisen through a period of years. I think the town has taken tremendous steps in trying to address issues and problems that have arisen over the past number of years. There's a way to go, probably a long way to go, but this conference is certainly an example of how to tackle that problem and how to address issues that still are out there. It reminds me, and I'm going to ask your forgiveness in advance, I do not tell jokes or stories.
Are we going to change that now, Paul?
We're going to change that now. And so when I mangle the punchline, you'll excuse me. It's a story that I heard as a young fellow, and it talked about somebody who was a very, very unlikable character, who all his life did anything and everything that he could do to make people's life miserable. And it came a period of time that after many years of performing this act of this deed to others, this person died. And there was going to be a funeral. And there weren't too many people who showed up at the funeral. And one person looked to the other and said, who's going to give the eulogy? Somebody has to say something nice about this person. And they all looked at each other. And nobody wanted to stand up. Nobody had anything nice to say. And finally, somebody was pushed up, and they stood above the coffin and looked down and thought for a while and said, his brother was worse.
Paul, I can't wait to see how the BZA fits into this story.
The answer to that is there are more difficult places to be than North Hempstead.
Okay, and
it's a matter of degree. We all have our favorite villages or towns where we feel more comfortable, where we feel the process is better, but we also have experienced municipalities where it's been worse. And so, one, I congratulate the supervisor, and I will personally embarrass David and the other members of the board for really trying to do the right thing. The zoning board is a relief valve. It's the place you go to when you have no other choice because something went amiss. It is, in fact, a quasi-judicial entity. It carries on a role of a court. I look at it as a court of equity. Yes, it's guided by law, but it's a court of equity. There are 5 elements in a use variance. There are 5 elements of an area variance. And it, with respect to an area variance, is a weighing. It's a weighing of benefit and detriment. And so it is this board that has to put the benefit to the applicant on that scale as compared to the detriment to the community. And the only advice that I would give to the board is never forget that that applicant is your neighbor, that that applicant lives within the town, and though there may be a handful, and there are only really a handful, of people who approach that line and cross that line deliberately, the greater percentage of the people that come before the board have to be dealt with fairly and have to be dealt with as your neighbor.
Thank you, Paul. I think what Mr. Bloom meant to say is that North Hempstead BZA is somewhere in the middle. Our distinguished town attorney, Rich Finkel. Rich.
Thank you, Mr. Brothers. This is the first presentation that I've ever heard people clap for Mr. Bloom, so let's do it again.
One other.
Oh, yeah. I'll be brief. The town attorney's office has 2 deputies, the chief deputy and another deputy, Linda Zuick and Simone Freeman, who are assigned on a rotational basis to represent the board in its deliberations, in its hearings, and in its drafting of facts. They do that also with the help and the counseled assistance of Gerard Terry. And since I've been here for 8.5 years, they've done that very well. There's a process to challenge the BZA's determination. That's commonly referred to as an Article 78 proceeding. I can say that substantively, no challenge on the facts has been successful. If it's been successful at the trial level, it's been overturned by the appellate divisions or the Court of Appeals. So the board analyzes these cases thoroughly, decides these cases thoroughly, and is generally found to be correct, with the caveat being that the courts defer to the boards. So the board's decision will be sustained, this is generally for the lay people, if it's not what the law calls arbitrary and capricious, if it's not irrational, if it's supported by the facts, if there's some objective evidence to support that finding. I'm not going to take too long because Mr. Brothers took all my time. But what I would like to say this for the community and the populace and the citizenry out there who is coming out to oppose an application. This is not really legal advice as to how to do that successfully, but it's a principle that you all need to understand, because I think people are confused with respect to the BZA's role and what their role is in standing up and opposing an application. It is not enough that you oppose an application. Nobody wants a project going up in their neighborhood. Nobody wants a project going up next to their house. If your objection is going to be given any weight by a court or by the board, it has to be more than a generalized community objection. You need to speak from your own experiences, how that has affected you personally, with objective evidence that the board or the court can rely upon. So just remember that the next time you go before the board, or the next time you complain to an elected official or a board member as to why they didn't listen to you, oftentimes it's because they can't, because you didn't give them anything that they can rely on. Okay, thank you.
Thank you, Ms. Finkel. Mr. Mammina, you going to sit? You're going to sit.
I'll sit. That's fine.
Our distinguished BZA chair and a good friend to so many in town, Governor Dave Mammina.
Good afternoon, everyone. I know many of you who are sitting here. And I'll start with a BZA joke in which we say we may be arbitrary, but we're never capricious. And I think just a little bit about myself. Again, I think many of you know who I am. I've been a licensed architect for 31 years, and I've had my own practice for 25 of those. I was in New York City until 5 years ago, and 5 years ago we moved our practice out of the city into Long Island. And the best thing I have is that I live 5 blocks from my office. So I mean, that's a very nice thing, and I'm very happy, to be in the town. I think just picking up a little bit on what Mr. Finkel said. I could remember sitting in the town of North Hempstead zoning board probably 25 years ago as an applicant. My hair was much darker, than it is now, and it was probably a little bit longer. But I sat there and I said, oh, I know what I'd do on this case. And, oh, I'm sure. I know exactly what I would do there. And then suddenly I was sitting up on that board about 3 or 4 years after that, and I'd scratch my head, because there is an emotional side to every single case. And, I'd like to believe that the success of the zoning board is kind of vetted out by the fact that, to the best of my knowledge, the residents think we do a good job, and the developers think that we do a good job, and I believe that our town council believes that we do a good job, and that's why most of us have been there for a really long time. And there is that balancing test and that weighing. No one's always right and no one's always wrong. When somebody comes with 50 people opposed to an application, we get really scared, but we still have to look at the facts. And the facts are not easy. I do think that when I came there as a young architect, I had no idea that there were tests of law. And I'd say, but look, my project is so beautiful. How can you not think that this is good? But beautiful has nothing to do with what we do at the zoning board. And I do remind people all the time that we're not an architectural review board, and we can't determine if red is a better color than yellow. It's not really what we're there for. To the applicants, what I will say, some of you may wave your hand at me, but I do believe that we as a board, we take process very seriously. We take the laws very, very seriously. And, when people will call me and say, well, do you think I need an attorney for something? I say, well, how important is this to you? Now, I'm not saying that an attorney has to represent every single application. But, at our board, we do get a lot of people, and we've even had attorneys that don't understand what are the tests of an area variance, what are the tests of a use variance. And they put their client at jeopardy, in my opinion. And, we do, with some frequency, invite people to just, ask for postponement and, come back prepared, especially after they see the types of arguments that people have put on the record. I will also, urge the architects and engineers, and believe me, this is not a holier-than-thou kind of a speech, because I make mistakes. When I make them, they're whoppers. Maybe, once every couple of years, I'll come up with something that I say, oh my God, how did I miss that train? But at the same time, people in my office, they do work and, and they're not as keyed in as I am. But be thorough on your analysis of the zoning, whether or not, it complies or it doesn't comply. I'm of the extreme opinion that it's not up to the building department to check your homework. We're not in school anymore. And I think that the architects and engineers, have a role in which they should be doing, that checking. And if they make a mistake, they make a mistake. I've made mistakes. But when people point, especially, architects and engineers point to, but the building department said, that doesn't help us. That doesn't help us to stand on firm ground. So, I'd like everybody to just kind of keep those things in mind. And, we'll answer any other questions when it comes down to that.
Thanks, Dave. Thank you, Chairman Mammina. Since I am the panel chair and I have the microphone, I want to mention we're so proud of our BZA governmentally and institutionally, and we have a lot of distinguished alumni, including 2 present sitting district court judges. Our most recent past alumni, I'm looking at her right now, and I'd like to give her some recognition. Our wonderful, relatively new councilwoman from the 4th District, the Honorable Anna Monahany Kaplan, who did such a fine job on the BZA. Thank you. The youngest man on the panel, Commissioner Michael Levine.
But in the town now, 16 years, actually 2 different shifts.
Can you hear Mike?
Should be the mic that does work. Okay. I've been in town for 16 years in 2 different tenures, and also spent about another 8 in both private and public practice and a certified planner. And actually began as a civil engineer. So I got more involved in the design end of things, and later got more involved with the legal end, the regulatory end. The planning department oversees land use policy and regulation for the town, also historic preservation, public transportation issues, environmental compliance, and as you've heard, we also, and everybody associates this with the planning department, we also oversee the staff end of the zoning board operation. And for that, I presently have 2 full-timers and a part-timer. And in the past, we had a staff of 4, unless a couple to retirement. So we're down a little bit from where we were, but we're still able to process the cases in a timely manner. We see between 300 and 400 cases a year. And what's remarkable is it's very consistent, fluctuates with the building permit volume, in that it seems to be steady at 5% of cases. So usually the building department sees 6,000 applications, we'll see 300 appeals. In years where, this past year, where there's 8,000 permit applications, we'll be close to 400 appeals. Staff job, staff is involved in 2 areas. First is to take your appeal, prep it so that the case and you are prepared for the hearing date. And then following the decision, the staff then has to publish and distribute the decisions before your building permit review resumes. The staff does not directly take part in the deliberations, however, other than to supply extra information as needed. So a little few points about what the staff can and can't do, because we get a lot of questions at the counter that we may be equipped to answer and be proper for us to answer. So one of the things that we will do, we can advise on how a hearing goes, what to expect on the day of the hearing, where you're going to be in the calendar. How long should the presentation take? we can offer some guidance as to, we need a traffic expert, we need a real estate expert. But again, it's guidance only. The staff will not necessarily know all the nuances of your case and really cannot do your preparation for you. You can't appear in front of the board and say, well, I didn't bring a traffic expert because stuff like you need one. Again, we're offering you a rundown based on the nature of the case, what we think you're going to need, but it doesn't be a substitute for doing your own research and evaluation. One thing a staff absolutely cannot do, the rest for this all the time, you think we'll go for it, you have a chance. When the argument is approval. And I've trained the staff to answer very candidly and somewhat evasively. We can tell you historically what the board has done. We can report on the history of this nature of case is. This is something that the zoning board does have a pattern of granting or not granting. That does not mean, though, that something about your presentation or present opposition is not going to deter it. We cannot make a prediction that they will or won't go for something. I'll tell you what they've done in the past. It still comes down to how solid your presentation is and what evidence is presented to the board, both pro and con. And the other thing that we cannot do, and rest this all the time, you take a look at it. Do you agree with the plan examiner? Can you go have a talk with him? Like bring him down to the office. I want to have a talk with him. We cannot arrange to have a showdown between the applicant and the plan examiner, but also the staff is not there to second guess the plan examiner. That determination is considered valid and final until and unless the zoning board overturns it. So while we may have our own, certainly derive our own opinions of the case, we're not there to advocate for you. You put in a good word for me with the board. The staff is not able to do that. We'll convey all facts. In fact, if you have supplemental information you want to get to them in written form, we will, if it's appropriate, we will provide that and distribute that. But I can't put in a good word for you with the board. It's not a staff function. Now, following the case, so the staff does not directly take part in deliberations. Within 3 to 5 business days, the written resolution is then filed with the town clerk, sent to the applicant, distributed to building department or the necessary party. Again, typically 3 to 5 business days after the hearing. At that point, the review resumes with the funds examiner.
Wow, great. Thank you, Mike. Thank you, Committee. That was a very short course. The distinguished Mr. Migatz, I'm going to introduce him without making a joke. How's that?
That's a switch.
All right, we can use the phrase Grim Reaper in introducing Mr. Migatz if you want. No. Bruce is one of the 3 distinguished practitioners on the panel today, and he is an absolute joy when he comes in and makes a presentation. He knows what he's doing, and he puts it all on the table and makes a beautiful record, and we're very, very proud in a, not in a, kind of an adversarial sense, but we're very, very pleased that Bruce is a major participant in what we do in the BZA. Mr. Migatz.
Bruce Burberry. Bruce Migatz. I'm a land use attorney with Albanese. I am, by way of history, I am former chief deputy town attorney for Hempstead before Gerard was born. In that capacity, I serve as counsel to the zoning board. I'd like to recognize Mike Affronti, who I think is still here, prior member of the prior chairman of the zoning board. He left. And John Fabio, also on the zoning board, also on the town council. I served as their counsel. I also served as village attorney, counsel to the village zoning boards. I've lectured on zoning in various forums. But I'm here today to add constructive criticism, and I emphasize the word constructive. The purpose of this conference is to vet the building department process and to discuss the good points and the bad points. And I say constructive criticism because I have the highest regard for Chairman Mammina, all the members of the board, council. They are truly, truly committed. I don't always agree with their decisions, but I can tell you all of them are truly devoted to what they do. They put a lot of time into it. One way to make the process better for everyone, so we're better than just his brother. For the applicants, and Mr. Mammina touched on this, you really should appear with counsel. It sounds like a self-serving statement, but it's true. And I've spoken to architects at their seminars, and I tell them that you should not be making applications to zoning board. Expediters should not be making applications to zoning boards. Builders should not be making applications. It's a quasi-judicial body. There's a strict set of laws that govern it. You have one bite at the apple. Clients call me, they make the application themselves, or the architect makes the application, and then they want to take an Article 78. Well, it's 9 out of 10 times it's too late, because the Article 78, the challenge to the court to review the zoning board's decision is based upon the record before the zoning board. You cannot introduce new evidence. So they come to us, I'm sure Mike has had the same experience, and Paul, and we don't pick a case 9 out of 10 times because you haven't built the proper record. And it's frustrating for you. I see the frustration in the homeowners' voice when they appear before the board, and the zoning board tries to help you go through it, but it's frustrating, and it makes the process better if you have legal counsel making your applications for you. The zoning board can make the process better as well. And way too often, this zoning board interrupts the presentation. And it drags on the presentation. It makes it disjointed, and it just makes for a very bad experience. I urge the board to let the unless you have a floundering lawyer who you have up there sometimes, or an architect or a homeowner, and architects make good applications sometimes as well. I'm not trying to knock them, but unless you have somebody who is floundering, please don't interrupt us. Don't interrupt the experienced land use attorney. Let he or she make the presentation. I can guarantee you, in my presentation, 9 out of 10 times, I'm going to answer the question that you interrupted me to see. But I'm going to do it in an orderly fashion so that it makes sense on the record. And it would just make the presentation faster, smoother, and a better experience. You always have the right to interrupt us, Mr. Chairman, other members of the board, but I really think that should be reserved for unusual situations. Let us make the presentation and then ask us the question. Can I just interject here? No, just kidding.
I didn't want, I was dying to do that.
I was going to get to that. And I say that in a constructive fashion. The questions the board asks, 9 out of 10 times they're good questions. But just, we'll get to it. I can guarantee you, Mr. Chairman, we'll get to that question. And if we don't, ask us at the end. Lastly, before I take up too much time and get myself in too much trouble, this morning, Supervisor Kamen, said you have to meet the code. We can't go outside the code. And this afternoon, David Mammina said we take the laws very seriously. The law says, Town Law Section 267-A, that the zoning board must render a decision within 62 days unless the applicant consents to an extension. And that does not happen very often.
There are cases that are on that, and I'm very happy to hear that the board's going to have administrative meetings to deal with the backlog. But the law is the law. We've been hearing this from the town officials all day long. You can't bend the law. There's nothing more frustrating to an applicant who has a lease conditioned upon getting a zoning approval, the sale of a house conditioned upon getting a debt, money in escrow. There's nothing more frustrating to that applicant than to wait 6 months, 9 months for a decision. The law says 62 days unless you have the applicant's consent. I've never once been asked to consent to reserving the case more than 62 days. Many times an applicant would consent to that. Many times they won't because they have a conditional contract. And they can't. Make a decision, and good or bad, we have a decision. If we don't like it, we can take it off for 7 years. But it is just, it's not doing justice. It's not what the law says. And I urge the board and council, follow the law. Make a decision within 62 days, or ask us for an extension of time to make that decision. Those are really my only 2 complaints about the zoning board. It really is a fantastic institution. They do a fantastic job. It can be frustrating because going to court can be frustrating. But if you hire professionals, if you go make the application yourself, be prepared. You can't just walk up there and say, I want this step. You have to be prepared to make the application, and they do a great job. Thank you.
Thank you very much, Bruce. And I guess I'll tell you, after the panel, your case is counted for May 9 and May 23rd. They've been adjourned to August.
Well, you decide in 62 days.
The third of our distinguished practitioners, Mr. Michael Sahn, who will also hopefully refer to the fact that he himself is a BZA chair somewhere else.
Absolutely correct. Thank you, Gerard. First, I want to thank the supervisor for inviting me to participate in today's discussion. I think it's a remarkable day. I don't recall a day when any other municipality has undertaken this kind of initiative in the public. So it's certainly worth a great deal of recognition. I also want to thank Richard Finkel and Gerard Terry and Dave Mammina and my colleagues for allowing me to participate, as well as a lot of the distinguished colleagues I have in the audience today. I do have a unique perspective, I think, because like Bruce, my first job out of law school was with the town attorney's office in North Hempstead. And like Bruce and like a lot of younger town attorneys, over the course of time, we proceeded through the ranks and eventually ended up as counsel to the zoning board for a number of years before heading into, I apologize, wasn't holding that close enough, before heading into private practice. So that has given me a unique perspective on zoning. And I went on to also serve for many years now as chairman of the zoning board in my village, Flower Hill. I see some of my village officials here today, so I'm very proud of that service, that community service. And I'm also proud that in private practice I have the opportunity to represent several municipalities where I serve as counsel to the zoning board. So I have some points of guidance that I'd like to share briefly, based on what I feel is my experience on all sides of the issue. First and foremost, in the recent years in North Hempstead, the zoning board has had to deal with a number of cases that have presented very difficult, factual scenarios. And in law school we learned there was an old phrase that hard cases make bad law. Whether true or not, as applies to the zoning board, difficult fact situations lead to lengthy and difficult hearings, and I think the board has done a yeoman's job in getting through those difficult situations, and I think the initiatives that are now being undertaken will resolve a lot of those issues. But I have noticed that over the years, many applicants, including those represented, I have to say, by counsel or by architects or other professionals, don't have a full understanding of what they have to do at a zoning board hearing. They don't understand the law applicable to a use variance, a special permit, an area variance, or other types of relief that is available before a board. So, as a general point of guidance for everybody on all sides, I would like to see initiatives undertaken whereby the applicants will have an opportunity to understand what their obligation is when they appear before a board. Some municipalities do present a fact sheet, so to speak, to applicants when they file an application that give them some guidance on what they have to prove if they want an area variance, for instance. That could be very helpful and could, without giving legal advice, of course, which the board can't do, put more focus to the hearings before the boards. So that's sort of my first point of guidance. The second would be to provide applicants and board members and staff with greater opportunities to interact before a hearing. In a smaller village where there are fewer cases on the calendar, it's easier perhaps to have some interaction pre-hearing, again in an appropriate way, without providing legal guidance or without answering the question that is often asked, as Commissioner Levine said, will I be successful? But there are opportunities to provide guidance in how to structure a case, how to focus the issues, how to present those issues, and what concerns might be raised to you so that you have a full and fair hearing before the board. So I think some initiatives to increase those opportunities would be very worthwhile. For the applicants, there's an old adage, if you don't ask, you'll never know. So it is wise to ask the staff about the issues that are being presented and perhaps schedule meetings with Commissioner Levine or with staff at the zoning board to at least understand the procedures that you have to follow and what issues are going to be presented and what you have to prove to make your case. And I would like to see perhaps the town, in conjunction with the applicants and all of us who are here today, undertake some of those initiatives. I would like to also, in the context of the commercial cases, suggest that Commissioner Levine, who is a great resource, has been at the county, has been at the town, as he said, this is his second stint at the town, become perhaps more involved in some of the commercial cases, especially those where there's an overlap between the zoning board and the town board. As many of you know, a lot of commercial cases require not just zoning board approval, but site plan approval before the town board. Those are two different types of applications, two different levels of proof, two different types of presentations that have to be made, but they have to be coordinated. So on those types of cases, Commissioner Levine's office can be a great resource, and I would like to see that expanded in terms of the coordination among the various boards and staff. I would like to also see more involvement perhaps with the building department on the appropriate cases attending the zoning board hearings. In the villages I represent, we always have a representative of the building department attend. It's easy because it's a small village. We have one building official. That building official can attend the hearing. And often in my village, Flower Hill, when I'm the chairman, and I try to keep myself as the chairman in that scenario, when we have questions, I defer to our village building inspector to clarify for the board. Many of the applicants presently and in recent time have become more sophisticated in their applications, and they asked the board for a determination as to whether the building department was correct or not correct in their interpretation of the code. And the zoning board often struggles with that because they are viewing the application without benefit of the building department's input in person at the hearing. So sometimes in appropriate cases, again, it might be worthwhile to have a representative of the building department present to add to that discussion on the record, so to speak, to move the case further along in a more appropriate manner so that the deliberations can be understood both by the building department, the applicant, and also by the zoning board. So those are sort of my guidelines. I think they require greater flexibility and greater effort on behalf of the applicants, the architects, the engineers, the board, the town, and I think today is a wonderful opportunity to start on that path. So I want to thank everybody again. I hope some of these comments are helpful. I take all criticism of my thoughts, and but in the vein of the purpose of the conference, again, I thought this would be a nice opportunity to present some of my own personal thoughts on the issues. Thank you again, Gerard.